Anya Lina Lester, and I'm the managing attorney for the American Bar Association's Commission on Domestic and Sexual Violence. Thank you for joining us for the fourth part of our four-part webinar series with the Alliance for Hope International on strangulation and civil legal representation. Today's webinar is about advocating for your client, and so today we hope that you participants will gain an overview of risk assessment tools and other resources that are available, as well as steps that civil attorneys can take moving forward to advocate for and support victims of strangulation. If you missed any of the three previous sessions, you may find the recordings and transcripts on the ABA website. I will repost the link in the chat box for you now and throughout, and you will also receive links in a follow-up email that my team will send to you as this series closes. As always, please post your questions in the chat box, and either Carly or I will have them answered during or after the webinar. We at the ABA are grateful for all of the expert faculty from the Alliance for Hope International and what they've shared with us. And now I'll turn it over to Gail to dive into the content and set a framework for you for today's webinar.
Well, thank you, Anya and Stephanie, so much. We are so grateful that everybody came back. How cool is that? And I love the fact that in the chat, it's already turning into a freeway where people are saying hi and where you're from. That's pretty cool because we can't see you, so it feels like I'm talking to myself. But I know that's not true. I know you're all there. But we're grateful that we get this chance to kind of wrap things up on our session number 4 to kind of give you some final tools and tips and recommendations as you go forward now doing more for your clients. So first and foremost, you always got to say thank you to your sponsors. And for us, we are forever grateful to OVW for making this training possible. It was back in 2011 when we received our OVW grant to really focus on this issue, which I think is a homicide prevention issue and initiative. So as you know, I'm the CEO of Alliance for Hope International and co-founder of the Training Institute on Strangulation Prevention. All of this started because 2 teenagers died under my watch, and I committed to their parents that their daughters would not die in vain. So each and every time I get to do training, I feel that I live up to that promise and in some way try to change the ending for other survivors. Because by definition, as you know by now, if you are strangled, you are a high-risk victim. You're probably suffering from PTSD and or a traumatic brain injury, and most people have not received this training. So there is an overall misunderstanding about strangulation cases. So what we wanted to do today before I get to Margaret is each one of us decided we were going to make like our pitch. If you were to remember anything from today, what would that be? And for me, I would say it's do more. Most recently, we came up with that mnemonic, and do more, you can go right down the list, is to document it in your pleading somewhere, to observe, to encourage your victim to receive medical attention, offer hope with that R is that risk assessment, and E is to educate. So that's my pitch for today as you walk away from this training. Margaret, what's your pitch?
Good afternoon and welcome back. I would encourage you to educate and mobilize your community. I've been in contact with our police chief and our local chief district court judge, and I plan to get in touch with the Chief Justice of the North Carolina Supreme Court to hopefully mobilize our community about the importance of strangulation.
Thank you, Margaret. So not only
And for me, thank you again for allowing us to work with you in this. For me, if I remember nothing else, I remember seconds to unconsciousness, minutes to death. That means we don't have much time. So as civil lawyers, it is up to us to ask the right questions, to observe our clients, and to document, because we are documenting the history of this strangulation for our clients' future. Additionally, we are doing it to keep our clients alive.
Thank you, Margaret. and Alexandria. I appreciate your words of wisdom. And I also want to just acknowledge the two of them one more time. It was back in 2011 that we did an article for the American Bar Association. It was Casey's My Way to say, you know, we've been focusing on this issue on the criminal side, and it's time for us to focus on the civil side. And it didn't happen. I was sharing the story with Margaret and Alexandria, and then I remembered why it didn't happen, because you need champions. And I think that's probably another theme of this, is that we need each and every one of you to take this back and do something. And both Margaret and Alexandria, just in the process of us getting together, in the process of putting all of this PowerPoint together, all of us have actually done more, because it does inspire you just kind of thinking about it. And the more you think about it, you realize that there are tremendous gaps in the system, and the only ones that can do it is probably the people in this room, in the sense of this webinar room, to get this information out. So what we're going to cover today, we're going to give you, like I call them, like the top 10 tips that all of us can do to advocate for our clients. We're going to emphasize some of the things we've already discussed, but we're going to add it and describe it in a different way. So let's just go ahead and jump into it with some poll questions. Our first one is, do you believe that victims understand the danger of strangulation? And it looks like people are signing in. And there could be people who decided they're not going to play with us yet. Okay. I think things have slowed down there, Stephanie. Whenever you want to close the poll, we can keep going. And I'm not sure if the results pop back up. There you go. And it looks like false. Victims understand the danger of strangulation. False. I think there's a little bit, could be like a trick question, because I believe in the heart of hearts when victims are strangled and they think they're going to die, they know it's dangerous. But I also think because it's been minimized by the system and probably their abuser, and they see no visible injury, it's hard for them to understand. So that's our job, and that's where we jump in. So going forward, one of the first things we wanted to do as we jump in is, how do you continue to educate yourself? Right now, this is the first training for many of you, but some of you have already had strangulation training before, so that's wonderful. And I think I want to emphasize this. It is really important for all of us, if we're going to be able to communicate the sense of urgency that I know I feel now that I know so much about strangulation, and the sense of duty to educate your clients, victims about this. The more you understand this, the more you feel comfortable, the better you will do in communicating this, and more information will come out. Most recently, I was reminded of this. I had the honor and opportunity to train hotline workers at the domestic violence hotline. To me, they are like royalty, because since we have the National Domestic Violence Hotline number, I've been giving out that number to everyone. I still give that number out when somebody calls me from another state, and what should I do? I always say start with the hotline number. And for me to be able to meet them face to face, I was just so grateful to be able to thank them. And as I was having conversations, because my job that particular day was to train every single shift of hotline workers about strangulation. And they had already received our online training, but what came out as a theme and out of the evaluations is they said the first training they understood it, but it wasn't until after they had additional training were they able to communicate it in a way, and they themselves noticed the difference by having more and more training. Because at first, one hotline worker said, when I brought it up, she was uncomfortable, but then I realized I was the one that was uncomfortable talking about it, and she hung up. But the second time I had that opportunity, it went much better, and she shared much more. So that kind of always reminded me about the need to educate ourselves first, and to a level where I'm not saying you need to be an expert, but I do think you need to be a specialist, because you're the one to have to bring it all in and educate everyone around you. So if you go to our Strangulation Training Institute, you will find a lot more. We have a resource library there with prior webinars, prior tools. But I would also say, Carly, let's definitely put this in their toolbox, is we have about 15, maybe 20 articles now that I think every professional who's working on a regular basis with strangled victims should read. So guess what, friends? We've got homework for you. But here's the cheat sheet. We came up with this media guide through our work with OVW, and our goal was to start training and educating the media. Because even today, as we do communicate with the media and we try to educate them, one thing happened actually to Casey Gwinn when he was being interviewed about strangulation. He was saying we need to use the word strangulation, non-fatal strangulation, or near-fatal strangulation, depending on the circumstances. We say near-fatal if we know someone has passed out, urinated, or defecated, because they are being strangled after the point of strangulation, so their intent is pretty darn clear. But the reporter argued with Casey Gwinn and said, no, the word is choking, that we have our standards, and in our standards, we use the word choking. And I said, oh my gosh, I can't believe we're having an argument with a reporter based on sort of their dictionary that was established many, many years ago. So we said, okay, it's time for us to continue to educate the media, and we came up with this kit. We gave the kit out to all of our advisors and say, okay, give us feedback. Is it working? What happened? How are you using it? And then it turned out that most of our advisors and faculty members were actually using it as part of their own training. So in it, you will find quickly a lot of the background about strangulation, some of the statistics, and how to get more information. We also reached out to survivors for their permission to use some of their quotes, and also our professionals. So things that you can use as you go forward. I say sprinkle it into your pleadings wherever you go. A couple of other resources, because I think Alexandria and Margaret made a very good point the last time we were together, that everything that we have learned on the criminal side can be applied to the civil side. So no need to reinvent the wheel. California came up with the first manual on how do you investigate and prosecute strangulation cases. I have some good news for you. That was created back in 2014. We have finished a new manual with all the new information that we have learned over the last 6 years. I'm told it's coming out the week of September the 7th. We will get this back to the council and the ABA, so you will get a copy hot off the presses. Then we decided to challenge other states and say, hey, California did it first, but by all means, do not reinvent the wheel. We will give you our entire manual. You just need to improve it, make it better, add more chapters, or put in your secret ingredients and your state law. Well, only one state took us up on that, and that was Alaska. But to their credit, they did a beautiful article on pediatrics. As you can imagine, if your client is being strangled, I would have a sneaking suspicion that everybody in that house is also being strangled. That can include the children, the elders, and definitely animals. So we're seeing a high correlation between animal abuse and strangulation. So that one is a really good chapter, but as I said, we have updated the California one, so stay tuned for more information. And now I want to turn it over to Alexandria. And Alexandria, we'll talk a little bit more about what do we do when victims recant.
We all know that victims recant. Some studies show that it happens more when victims have been strangled. It may be a victim's thought process. is jumbled, but more importantly, if the system minimizes strangulation, then why not the victim? Now, I am not talking about those that choose not to proceed. I am talking about those that become uncooperative victims or those that recant prior statements and will not even show up. They become unavailable. The one thing that is most important is just because a victim recants doesn't mean it didn't happen. It may be nothing more than the system minimized it. Also, over time, a victim may change their mind. Abusers may provide more resources than the system can regarding children, economic security, and housing stability. However, there are things you can do. And before I go there, I want to talk a little bit about what abusers say to their victims. They say, and Gail, next slide. Before I tell you that, one of the things that I think everybody needs to do is read this article. This article explains the cycle on recantation when an abuser may attempt to rewrite history, try to confuse the victim about what really happened, who's really to blame. That abuser may minimize exactly what happened. That abuser may make excuses for what happened, then apologize, send gifts, promises to change, may blame that victim for the arrest, make that victim feel guilty. They may even talk that victim out of appearing in court. And there may be threats. But what is most interesting is that recantation wheel that was in that article. There seem to be 5 stages of witness intimidation. First, the victim first decides, I'm going to press charges. So he calls her, oftentimes from jail, and discusses the abusive event. They both go back and forth. There's mutual blame, there's resistance, there's anger. And then the next time, he minimizes it. He blames her to lessen the severity of exactly what happened. And then he does what all perpetrators do. He uses sympathy to become that victim. And sometimes that victim becomes the perp. Then he begins to say, look at what life we had together. Let's bond over our, he doesn't say it that way. They bond over the memories, their dreams of a future. Then he begins to position both of them against the others, the system who doesn't understand them. Then he instructs that victim to recant. And if she complies with these instructions, he says, no one really knows what really happened. We do, and it's all right now. And then, again, his appeals of sympathy. And then the couple bonds against that system, and they reconstruct that recantation narrative. And within that, there's more relief, there's excitement, and unfortunately, there's hope that the relationship can survive. Amy Benami and her other authors looked at jailhouse calls. It would be very interesting in all your states, not just look at the jailhouse calls, but learn whether those can be admitted into evidence. Because jailhouse calls, photos, EMS reports, police reports, body cams, recorded 911 tapes, recorded statements can be used in lieu of a victim or with a victim who chooses to become uncooperative. If one has independent documentation, a prosecutor can move forward on the case. I have a recent case where I looked at the police report because the police did not take it seriously and called it a verbal argument. Both were primary physical aggressors. Both grabbed each other and broke phones. She was drunk. There was minor redness on her neck. They went so far as to call EMS, who took her to a SANE nurse at a hospital. But they would not press charges. They did not see this as any issue. So you can see that independent documentation can go a long way. Thank you. Margaret.
Thank you. But before we go to Margaret, I just want to add something here. Recently, I had some feedback from advocates working in the criminal justice field, and they pointed out that they've been sharing the stages of witness intimidation with survivors, and it's had a very powerful impact, just like when we talk about the power and control wheel with survivors. So I was just kind of thinking about the 5 stages. I mean, Alexandria, instead of pressing charges, victim applies for a restraining order. And the same thing will happen until she fails to show up for the permanent restraining order hearing. So I just had to jump in and say that because it was good news, and I just want to share good news today.
Absolutely.
Margaret?
Okay, thank you, Gail. We encourage you to listen and look for clues of strangulation. What did your client say? He held me down. He grabbed my neck. He choked me. He pressed me against the wall. He squeezed my neck. He tied me up. He was on top of me. I couldn't breathe. He was in my face. He gagged me. And look carefully at the reports from the police. What they described. Was the victim's face red? Was she coughing? Was she shaking? Could she respond to questions? Did she appear intoxicated? Was she unsteady? Was she even uncooperative? So listen carefully and look for clues of strangulation because victims may not remember being strangled or suffocated. The lack of oxygen that they've experienced prevents memories from being formed. Trauma caused their ideas to be jumbled and suppressed. And some people may not think it's significant to even tell you. And very often people are embarrassed. So they may have no visible injuries. They may feel that they are fine. It's no big deal because it happens all the time. So listen and look very carefully. The client came into the Family Justice Center here and asked for a consultation. Her main concern was about custody. She was pregnant, and the father of the child had repeatedly told her he was going to take her child. I noticed that she was quiet, very subdued. She seemed afraid, and she seemed to be hiding her pregnancy. After I talked with her about an hour, she mentioned that she had been strangled. And so, therefore, we conducted safety planning, and I referred it to our high-risk team. We have a high-risk team wherein we do a staffing within 24 to 48 hours if a client presents with one or more of 13 factors, and one of those factors is strangulation. We convene the team. Presentations are made about what has happened with a timeline of the violence that the client has suffered. We get the offender's criminal history, and we try to come up with a plan to get that client to safety and also to prevent them from being killed. It's a good way for our partners to engage. Very often the high-risk team addresses the worst of the worst cases because we are trying to prevent homicide. As a result, the high-risk team has been in effect ever since our Family Justice Centers opened in 2015. We have one in both locations in Greensboro and in High Point. As a result, we've had increased convictions because we very often work with the district attorney's office, and it has increased victim engagement in each center. So we encourage you to listen and look for clues of strangulation, particularly when the person doesn't seem to be giving you all the facts, because very often there are other issues going on with that person as a result of being strangled that may prevent them from articulating it in an orderly manner. Gail?
Thank you. And you raise a very good point, Margaret, because as you were telling your story, I couldn't help but think about Tanika. And we have stayed in touch with Tanika, and what Tanika shared with us after the fact, she said, you know, I do remember everyone insisting that I seek immediate medical attention, but I was too preoccupied about doing other things to leave. I was preoccupied in getting my restraining order. I was preoccupied in finding a new place to live. I was preoccupied on how I was going to do that and move my furniture and then take care of my finances. And so it was the sixth day after I felt I got everything done, then I was willing and able to hear what the detective and the advocate was trying to say. So they are going to be thinking about other things. And sometimes victims will think about everyone else except for themselves. So that was a very good point, Margaret. And here's what we learned. As you might recall, in our last webinar, I shared the result of the study that we did. And to my shock and surprise, I had mentioned that 60% of the clients who were coming to our restraining order clinic at the time had reported difficulty breathing at the time that they were seeking a restraining order. So I'm going like, holy cow. This is a time where we shouldn't be worried about getting the restraining order, which is yes, but first and foremost, it's her health and immediate medical attention. So we quickly shift to a screening. By that I mean is we're going to determine right now, do you need to get to the hospital first, and we can work on getting an emergency protection order through one of our police officers to give us the time that we need, because in California we do have the ability to issue emergency protection orders for victims for up to 5 full business days. And through COVID, that's actually been extended for 30 days, which has been a way for our courts and our state of California to deal with COVID. So I wanted to bring that back to your attention, because now if I were to put together my file for screening a client of domestic violence, it would probably be twice as large as the initial file I created for our restraining order clinic. And I would say by far this is the best tool to use. We talked about it before, but I want to talk about it again. It was developed by paramedics after they attended the 4-day advanced course, and they said, you know, this is our role and we can help too. They created part 1, which is signs and symptoms, which is something that they weren't screening for when they were dispatched to a scene of domestic violence. And then they came up with their own mnemonic about what they needed to do. And then, of course, they said when a victim should be strangled, and they have the delayed consequences there, things that they didn't know as paramedics, because as we mentioned before, there are only 2 states that even train paramedics in domestic violence, and there's no state that requires paramedics to receive training in strangulation. So you really will be training a lot of folks. What our medical team added was advisal to the patient, and I want to slow down here, because I think this is where civil attorneys can make a big difference, and you might have that moment where they're listening to you. They are trusting you to help them get that restraining order, to get custody, and get other things that they need. And when you say it, because you've been to this training and you understand that there can be internal injuries, and you understand that there can be delayed consequences a day from now, 2 days, 3 days, and you also understand that there can be a likelihood out of 1 out of 47 who might have a stroke, this is serious business. And I think coming from you as an attorney, that they are looking up to you and everything has been minimized by their abuser. This could be the very first time somebody says this and it lands. You also will see the hotline number there that I say everybody needs to memorize. And then comes the notice to medical provider. I would say the biggest feedback we are getting now is a lot of medical providers have not been trained in strangulation. They have not adopted the imaging protocol, and we have to educate them. And sometimes even when you give them this form, they ignore it. So Alexandria and I were kind of talking about, what would we do if that happened? I go, I might say to my client, if I couldn't be there with her, to say, you know, in a very kind voice, and say, my attorney suggested that I bring this with me and provide you with a copy, because there's a lot of new information that's coming out about strangulation that didn't exist before, so she thought this was important. No, I'm not going to have some attorney named Alexandra Bruton tell me what to do, because I'm the doctor. and I'm giving you a quote because this has happened to us. And then you can say, well, my attorney kind of thought you might say that, so I'm specifically requesting that you put this assessment card in my medical file, just in case anything bad happens to me. Now, everybody might have a reaction here, could set the room on fire, but as we talked about this before, there is reluctance. And even in the Tamika case, that doctor was reluctant to get Tamika an MRI, but only because of our persistence and the fact that the detective was outside did it occur. So I just wanted to highlight that. And as we mentioned before, the CTA is medically necessary, and given that there's a lot of bad things that can happen that we don't know, this is an emergency. This is a medical emergency that requires, under the federal law, to be screened. I just finished law school, and I had one of my law students write a paper on this. She actually did a really good job. So I don't know, Anya, that might be something that people might be interested in, but she decided to make the business case that hospitals have a duty to screen and assess strangled victims if you don't want to do anything else, that there is this federal law besides medical malpractice that can be a remedy for victims. So I will go ahead, and I think we're doing a chat. So warning, as I said before, your medical community may not be trained about non-fatal strangulation. So do you know if your healthcare provider is assessing patients for strangulation? You can just put it right in. I see Ruth Downing is here. So if Ruth's here, I know every hospital probably in a 100-mile radius has already adopted the imaging recommendations. But some of you may not have a Ruth Downing in your neighborhood. So we're getting answers yes and no and I don't know. Okay, that means we've got our work cut out for us. Thank you so much for typing in your responses. We thought that would be a great way to see, kind of do some benchmarking. Now, the next thing I want to say is few more things. So as you're advocating, in our world, we always like to say, okay, if we're going to change the world, let's dream really big. And if your dreams don't scare you, then we're not dreaming big enough. Because after I have done hundreds of focus groups with survivors, and the very first one I did at the Family Justice Center after we opened up, it really hit me that victims are counting on us to make the system work better. They can't fix it. It's up to us. So ever since then, I started to get this real sense of urgency to hurry up and fix it. And one of the things that I think we can use your help, because the power of we is going to make a huge impact. We've been advocating for domestic violence exams for victims of domestic violence, especially victims who are strangled, for years. We opened up our first forensic medical unit in 2003. I felt like it took us forever because once I started being a prosecutor, I realized we needed more for our victims even back then. But most recently, we tried to advocate, and you can see here, this was November of 2018. We tried yet again to advocate for domestic violence exams to be added into the Violence Against Women Act. All we wanted was 3 little words, because right now, if you're a victim of sexual assault, you are not required to pay for anything because you're a victim of sexual assault. So we suggested, can we add 3 little words? No victim of sexual assault or domestic violence shall have to pay. Well, it didn't happen, but as you know, you can't take no for an answer. So we can also start locally in your policies and protocols. We can also start statewide, and we have 4 states that have actually pending legislation this year to try to make it happen. But we have a lot of states here represented. So we have a lot of amazing people who are on this call. As your legislature comes up to you, because they usually come up to the DV people and say, hey, what help do you need? How can I help you? Why don't we add domestic violence exams to our state law? So there's my pitch for state law. We also have it all written up, all the key points, and that will also be in your kit. And we're also, as I mentioned before, creating a civil attorney's Dropbox toolkit. So that's one. Then I just wanted to brag about all the other communities. So here's what I've learned in advocating for change since the late 1900s. If you're the very first one it's going to take a lot of work. But if you can show to your city and or county that other cities and counties are already doing this and they're seeing success, it's much easier when you are not building like the first pool in the neighborhood, but others have done it already. So San Diego has an on-site forensic unit with forensic nurses doing both domestic violence, sexual assault, and strangulation. And the prosecutors there, everything went up by 40% once the forensic nurses got involved. They are brilliant at what they do, and survivors will tell nurses a lot more. And as all of you know, the medical diagnosis exception is alive and well, so we need to take advantage of it. Tulsa, Fort Worth, New Jersey, Erie County, Guilford, Buncombe, North Carolina. These are the ones that I know of, and there's probably others that I don't know of, but I like to add to the list and brag about great work that other people are doing. And I also would be remiss if we didn't talk about guns, 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 guns. Most recently, we just reviewed the domestic violence report that comes out every year about domestic violence homicides. It's called When Men Murder Women. I look at the last 5 years to say I'm hoping that we are still making progress, but as a lot of things are changing with bail reform and jail reform, I am seeing a decrease. So the good news is you're not seeing mass incarceration like we used to, but every kind of act has an equal and opposite reaction. As folks are getting out of bail, jail much sooner, and some jurisdictions are not considering dangerousness. I've been tracking where victims are being killed. So we're not talking about everybody. We're talking about DV offenders, and there's a reason why if you're convicted of domestic violence or subject to a restraining order, you should not own a gun, because a judge has already determined that you pose a credible threat. So I wanted to kind of highlight the most high-risk victims from New Orleans who were strangled. Their offenders, by 38%, had guns. So as we're advocating for your client and our victims, we need to make sure we get the guns away from those who are the most dangerous. And in the report that comes out every year, the number one reason women of domestic violence are getting killed is a gun. They're being shot to death, but before they are shot to death, they are being strangled, as what we talked about before. So I just want to kind of point out something about New Orleans. New Orleans is probably going through hurricane season again, and I'm praying for all those that are at risk for a hurricane, because it can be so devastating. And of course, California is suffering a lot of fire, and we got a lot of other things happening in America. But they created the New Orleans Hope Health Clinic, and not only are they able to provide forensic medical exams, but they're also being able to provide health care. And one of the things that we found in another survey that we did with survivors, that abusers are the ones that will keep victims from seeking health care and or even seeking dental care. So kudos to them. And also kudos to the folks in Rose Andom Family Justice Center in Denver, Colorado. They were able to open up their health clinic as well. So this is, you get to tell your community that if you don't have one, other communities do, and you can always go take a tour of their center, of their medical clinic. And then once you tour a family justice center, it's kind of like it will sell itself. And I think now more than ever, we need to continue working together as a team. Because going through strangulation is very traumatic. So, and speaking of traumatic, Alexandria is going to talk a little bit more about trauma.
Thank you. But Gail, I wanted to say one other thing, and this is for every every lawyer out there. It is never too late to ask your clients about any residual medical symptoms. After listening to Gail and having my aha moments, I have called every one of my clients. I have read what I wrote in the past. I look at what my clients, those that have been strangled, are suffering from now. I've called them all. I have asked them, do you have any residual symptoms? Memory loss, hoarseness, problems with vision, headaches, and if they have had any, I encourage them now to seek medical attention and to be screened. It is never too late to save a life. Additionally, I loved your idea, Gail, with having it put in the medical record. I also did one thing. I gave all of this information to the client. When the client said, nope, I have to set up a different appointment, this was the client where the police are not going to charge, I contacted the forensic nurse. And I happen to mention, you do know that if something serious happens to this client, your hospital may be in jeopardy. And that is all I needed to say. So now we go to trauma. And what I wanted to say is the one thing, next slide, the one thing that we don't have, trauma and the brain. If you can see one video that explains trauma, it will do much better than I'm going to do. It is so instructive. It explains how the brain works when there has been a traumatic experience, how that victim processes and is able or not able to tell their story, and how the police in this case, these professionals, were able to respond to be able to bring out from that victim their story. And so I suggest everybody find it and watch it. And I think, Gail, isn't it on isn't it in the Dropbox?
Yes, it should be in the Dropbox. It will be attached, and we'll give you a link to it, but it'll also be in the toolkit.
Okay, so we all know that assaults are traumatic. However, when you're a victim of strangulation, you may think you're going to die. That is even more traumatic. Trauma results from any event or series of events. It could be even one single incident or a set of circumstances that is experienced by a victim both physically and emotionally, and threatening them, and that has lasting adverse effects on that victim's physical, social, emotional, and spiritual well-being. So to spell out what happens, this is the next slide. This is your brain. And what happens is the brain's prefrontal cortex is what records and processes memories. It is what records information. And if you are suffering from a traumatic event, let's say like strangulation, that cortex becomes temporarily impaired. The hippocampus also becomes temporarily impaired. And that part of the brain is used to encode experiences, put them into short-term memories, create stories for them, and then stores them as long-term memories. Fear, such as that fear with strangulation, impairs the ability of the prefrontal cortex and the hippocampus to store contextual information. It is almost as if it reverts to the amygdala, which is that primitive brain where you're thinking of the fear, flight, and fright concept. And what we've seen is when the amygdala, which is known to encode emotional experiences as opposed to memories and reasoning, it begins to dominate. It triggers stress hormones, and it helps create fragmented memories. And what we find is that these clients that you will get have difficulty sharing their traumatic events. They have difficulty with decision making. They are confused over timelines. They can't track what's going on as well. And they have emotional regulation problems, and that may be hard. These are the clients that you have to prep significantly for a trial. These clients will come to you. They don't trust you. They don't trust anything about you. They fear the system. They have that impaired sense of safety, and they have impaired self-expression. Look at strangulation as a terror attack. It is terrorizing. Some victims have described it like drowning. The panic is mixed with an odd incredulity that this is really happening. I've never done that before. The body and the mind do not know how to die, gracefully or not gracefully. That process is filled with desperation and awkwardness. And in some cases, that single violent assault can instill enough fear in a victim that that abusive partner exercises complete coercive controlling behavior. And that is how they maintain their control. They don't have to strangle them more than once. Often they do. But if they strangle them once, they know how to keep their victims in line. Strangulation has also been considered torture. Non-fatal strangulation may be the equivalent of waterboarding, widely considered, of course, as torture. Both leave few marks. Both can result in a loss of consciousness. They are both used to assert dominance and control over the other person, and they create that intense fear that would result in death, and they can be used repeatedly. What is most important as a lawyer is that you learn trauma-informed lawyering. It took me a while. I remember, and I'm going back over all the cases, and I've been practicing for 35 years, all the cases I've had. And in Ohio, our state law is such that you need to note the nature and the extent of the violence in an affidavit or a statement. And you have to usually start with the most recent incident backwards. And you have to provide times, dates, and that's what our case law says. You need something. You need context for it. And that is what is hard for a victim to be able to give you. So instead of asking them, tell me what happened on this date, and this date, you look at it very differently. You help them, as Gail said, unlock their memories. What did you see? What did you hear? What did you taste? What was happening outside? And what do you remember? You let the victim of a traumatic event set the stage first, and then you follow their lead. So there are several tips for attorneys working with traumatized victims. You know their memories are going to be jumbled. You can't ask them to follow a linear progression as a way to get the story. They may not know dates. You may want to ask them, do you remember, was it in the spring or the fall? I don't remember. Do you remember smelling flowers or not? That may be something that they remember. And let me just say, going back to a civil case, when we go to court and we have to explain to the court what happened, and we put that client on the stand, and that client can't remember, you hear many judges, and you'll get it from the other side, defense lawyers, that guess what? They must be lying. This didn't happen. They would know if it happened. But yet, we can turn that weakness into a strength. We can potentially bring in an expert. We can use experts for recantation. We can use experts to talk about trauma. We can use experts to talk about traumatic brain injury. And we can talk about strangulation and how a victim may present having been strangled, having suffered from a traumatic injury. And we will be able, hopefully, as we know more about trauma-informed lawyering, we can address our frustration and we can address our clients' frustration. Those people in a family justice center already have the therapists, the counselors, the medical people, everybody is on site. They can all work together. But for legal sole practitioners and legal aid lawyers and lawyers that are not on site with the Family Justice Center, it's time to gather a list of therapists who are qualified to work with victims. You need to also make certain that you do the screening for medical attention, and you change as lawyers how you practice so you can get the most important information from your client. Margaret?
Thank you,
Well, I
Alexandra.
thank you. And before that, Margaret, I just want to remind you we've got a poll, so you let us know when you want your poll.
You talking to me, Margaret?
Yes, Margaret, sorry.
Okay. All right, let's do it now.
All right. I think Stephanie's going to move the poll. Maybe not. Or Anya, are you able to do that? And if not, we'll just move on. There it is. Oh, this is the wrong one.
No,
we
risk
should have the
assessment.
one about risk assessments. Oh, all right. We'll do them both. Oh, Margaret, looks like a majority are saying yes.
That's
These
great.
must be very well-trained attorneys and others. Okay, they're slowing down. I say let's end that poll and keep on going.
All right. All right. Utilizing risk assessments with the victims of strangulation can serve many purposes. With non-fatal strangulation, sometimes people do not know the risk that they are being exposed to. I never forget a situation where I told someone about the statistics about strangulation, victims of prior strangulation having a 750% more likely chance of becoming homicide victims. And according to Dr. Jackie Campbell, a woman who is strangled even one time has 1,000% more likelihood of becoming a homicide victim. And I remember her facial expression when she learned just that fact, that she was in such danger. So understanding the risk assessment can help you better plan to keep your clients from becoming homicide victims. But also, as an attorney, understanding risk assessment can help you in trauma-informed interviewing, in drafting your pleadings as you paint a picture of the horror and terror of strangulations, as Alexandra just referred to. It can help you in your opening statement. Of course, in your trial and in your closing statement, it can help you build your record, and it can help you educate your judge about what a victim of strangulation has suffered. So using Dr. Jackie Campbell's 2019 danger assessment tool, you ask the client. You've heard that the clients may not remember sometimes, and for various reasons. There are some clients who need assistance in developing their story. They may not think to tell you certain things. So ask them, have they been stepped on? Have they been pushed? Did he punch you? Did he kick you? Have you suffered bruises, cuts? Are you in any pain? And describe the level of the pain. Did they beat me up? Go into a little more detail. Did you have any contusions? Were you burned? Do you have any broken bones? Have you suffered broken bones in the past? Did he threaten to use a weapon against you? Did he threaten to kill you? Did you think he would kill you? Has he threatened suicide? by all means ask them how often they've been strangled, so you can determine whether or not there's been a pattern of escalating violence, which is very often the case. The frequency of it, the severity of it. Does he own a gun? Was a child present? Has the child been strangled? Has he threatened to do any harm to any of your animals? So these are some of the questions that you can ask your client to determine the risk that they're in. It can help you also describe to the court what your client has suffered, depending on whatever cause of action that you are using to try to address the severe torture that they have experienced. There's also another danger assessment tool and an app that you can download from One Love Foundation, which will aid you with 20 specific questions to assess the risk. And then the danger assessment for law enforcement has 11 specific questions targeted specifically towards multiple strangulation, because multiple incidents of strangulation appear to increase the risk for near fatal violence. So use these tools in trying to determine the risk that your client is suffering for the purpose of letting them know what they are experiencing and the danger that they're in, because some people may not be aware of it, but also to describe to the court what the client has suffered when you are utilizing civil remedies to try to help your client. Alexandria?
Yes. And this report that you see at the bottom from Case Western Reserve University, the way this came about is Cuyahoga County received a grant to implement the DV Homicide Prevention Demonstration Initiative. It was one of between 4 and 6 programs in the country. They had already seen that the LAP, the LAP, Lethality Assessment Program, and that's out of Maryland, that was useful in both predicting and dealing with high-risk victims of violence. So they thought maybe utilizing the 11 questions would also work. So we have 2 districts in the city of Cleveland that are utilizing that. We have other districts that don't have that but just have a vertical domestic violence unit, but they're not assessing for high risk. So in that high risk, we have 2 trained detectives. The high risk team is housed in our Family Justice Center, and if somebody gets a score over 7, they're considered high risk. They're provided with domestic violence services. So the question that the U.S. Department of Justice Violence Against Women Office wanted to know is this working? So what you're seeing here is the first report in May of 18. And it says that of all the people that were assessed in those 2 districts, 45% were at high risk. 88% of those were strangled. 88 had been threatened with death. 89% believed their abuser was capable of killing them. Those are significantly high numbers. But then they did a tri-year report, which just was released, and it went up to 46% as high risk. 90% were strangled. 93% believed that their abuser was capable of killing them, and same thing, 88% had been threatened with death. Additionally, 86% said that the domestic violence increased in severity over that past year. These are significant. And what is most significant about this is we already know strangulation is a predictor of homicide. I think it is time that we as civil lawyers help complete that circle. We have a very important part to play. The only thing I wanted to say, Margaret, with the danger assessment is since we have to do our client's statements, you could mix into the affidavit or the statement many of the danger assessment questions if for some reason they apply to your client. And then you may have a judge who has already received a bench card on all the lethality questions. And that will cue that judge. Well, listen, oh, I remember that this was a lethality factor. Strangulation was, firearms. This is all in here. And you may have a judge more sympathetic and likely to grant whatever orders you're requesting. And in our case, it would be protection orders. Okay, Gail?
All righty then. Actually, I think we have one more tip from Margaret.
Oh, Margaret, sorry.
Yes. So there may be times, as that's happened very often in our family justice center, because we have a cutoff time for getting our filings in so that the judge can hear them in both centers where I work. So get right to the point and describe what's happening. He has strangled me 3 times in the last 2 months, or he has been violent with me 5 or 6 times in the last year. He has a gun. He's threatened to shoot me with the gun. He brandishes his gun. I think he will kill me. I am scared for myself and my children. He's tried to choke me before, and he is very, very violent, and he's insanely jealous. Use words to get the judge's attention. Specify what has happened to you. And these 5 questions will alert the judge about the threat that the person is facing. And use the word strangled, use the word choke, use whatever you can use to graphically and accurately describe what's happening to the client. Because shocking behavior happens before sometimes, and most definitely sometimes after people get restraining orders. They are in an even higher level of danger. So if you don't have time to go into great detail, be sure to use words that accurately, but graphically and accurately describe what's happening to your client as you try to get a restraining order for them. Gail?
Well, thank you, Margaret, and you're certainly, both of you, emphasizing the need. I will just add one little side story about reading applications. Thanks to Alexandria, she was willing to share some of the petitions that were filed during COVID. And my law students obviously could not go to court to observe either a criminal case or a civil case. So I go, oh, I've got to do something to help them understand the severity of all of this. So they had a chance to read the Ohio petitions for restraining orders, and they made a number of comments. And one of the things that they said in the handwritten applications by survivors that drew their attention in was what they said and how they ended their application. And we found in the set of petitions from Ohio, a number of victims wrote in their own hand in all caps, "Please help me." And they underlined it. They had it in all caps. It was like in bold, exclamation mark, "He is going to kill me." Now that is very, very graphic, and that would certainly catch anybody's attention. But it's definitely important for us to help victims even say more about what they're experiencing. And that's one thing I regret, because I would ask a question and they would say, "I thought he was going to die, but I should have asked more. What did that really feel like to you?" And if they're able to do it without re-traumatizing them, judges, I agree, need to hear it. And I know we've got Judge Hyman on this. So Judge, if you can type in your recommendations when you've seen these cases, what do you suggest? So thank you, Judge. Let's keep on going. Now I want to go into explain the short, long, and long-term consequences of strangulation. Previously, I had mentioned that California has a law. It's called duty to warn. The police officers, when they respond to a call and they find a victim has been strangled, they have a legal mandate. They can't leave until they warn the victim that strangulation is serious, can cause internal injuries, and like, I'm concerned for your safety. Here's something that we drafted. As we are kind of now converting our tools from the criminal side, what does this look like from the civil side? So my recommendation to all of you would be, and maybe Alexandria and Margaret, we can do it for them too, but what is your advisal? When the next client that you work with and you find out that she's been strangled, what are you going to say to your client before she leaves? Because what I told my students is, TV cases are hard. They're very complicated. They're high risk. And we probably all have had cases where someone has died under our watch. And it is a horrible feeling when that happens. And so you end up going home that night and having this gut check and go, did I do everything possible to keep my client, my victim, alive? And at the end of the day, you want to be able to say, I did all these things. And hopefully we can prevent a homicide from occurring. But I think what we want to do is utilize best practices, and now we're having the ability and opportunity to convert this information. So what would it look like for you? And I would put that into my client file just so I can remind myself if you haven't committed it to memory. So here's a couple of things we've learned in our restraining order world. And the first time when we would let a victim know about how dangerous the situation is, we would share her score. We would walk through what we're going to be doing, the next steps, including safety planning. At first, this is all a lot of information to take in. So you've got to share it because you have a duty to share and a duty to warn, but anticipate that they're going to at some point come back to you and or need to learn more about what they're now feeling and sensing because they've had trauma. They could have PTSD. They could have some thyroid issues, other issues related to being strangled. And so this article, it was actually written in response to a survivor who came up to Casey after one of our trainings. And all of us who have trained have had this experience, is that there's always a survivor, at least one, if not more, who come up to us afterwards. And they have all said the same thing. And that's why it's called, why didn't somebody tell me? And when victims find out about this, they say the same thing. Why didn't somebody tell me? Had I known that I was potentially having brain damage each and every time he was strangling me, that I was more at risk of being killed, I would have left much sooner. And now I'm having all these consequences. And in this particular case, there was a woman from Washington who had suffered a series of what they call cryptogenic strokes. They really couldn't pinpoint it, so they couldn't say the cause, but she kept having repeated strokes. And we believe ultimately she had one more stroke and died because we have lost contact. And her doctor basically said if she had one more, she would die. So that was our way of honoring her. We never even learned her name, but it was our way of saying, okay, let's educate victims even more. So going forward, what else can you do? We created the victim brochure. It's in plain English. Oh, and by the way, going back to this article, it is in plain English, because if you read all the medical articles, you need a dictionary right next to you to try to understand it, or you got to hang out with a doctor who will interpret it for you. So I wrote this in plain English so everybody could understand, and I asked all the doctors, as you see their names there, to review it and tell me if I got it right, because I wanted to make sure it was written in plain English. So now going to the victim brochure. The victim brochure really is something to let the victim take home with. It explains what they're experiencing, it explains loss of consciousness, explains some of the signs and symptoms that could occur. And it allows them to journal what they are experiencing and to send it back to you. So we're getting good feedback on this. What we wanted to do is make sure it's available to you for free. So as part of our OVW grant, we can customize this brochure with your information, with your logo from your legal agency or advocacy, because I know we've got a lot of folks from a lot of different organizations here. And this is just something that will help victims understand what they're experiencing. So speaking of that, they're experiencing all kinds of things. So do we have another poll question before Alexandra joins us? I think we do, on the rate of suicide. Go ahead, Alexandra.
Yes. Before I start, I would like that poll question up. No, the one on suicide.
We got so excited about polls.
Okay.
We have a lot. There you go.
Okay. Well, good job. You're all right. It is true. So, next slide, please. So, the two things that I think are my biggest, besides all the other things that are my biggest takeaways, pay attention to your client's behavior. Not just the behavior that addresses the signs and the symptoms of strangulation. Because now that we know what we didn't know before, we will know what questions to ask. But it's that behavior where your client is sitting right in front of you and that client cannot remember. There are inconsistencies in what they say. There are emotional outbursts. There's frustration. That clients saying, I can't remember. That frustration, those are also things to look for. You can tell your client to monitor signs and symptoms, but you have to address trauma and trauma-informed lawyering to address some of these other things. So that is one piece I think is so important. The other piece is follow-up calls. It's calling your client repeatedly. What was not a visible injury, maybe on the day she came in, may become more apparent 2, 3, 4 days later. That with time, that client may come in with much deeper injuries. She may not have been hoarse or had a sore throat immediately, but a day or two later, she may have. If you suspect strangulation, but the victim has not reported it, that's when you ask all those questions. Hopefully, you will have a client who will then say, this is what happened. And you may not say, are you choked or strangled? You may say, did anyone impede your blood flow or your oxygen around your neck? That may be something a client will answer to. Now, I remember my clients would say choking. And the first time I used the term strangulation, my client absolutely freaked out. And the reason for that is choking she could minimize. Strangulation was much broader, much deeper, and she couldn't get her mind around that. So you want to detail what happened. Of course, you want to follow up, in the follow-up calls, encourage your client to get medical evaluation. That is so important. Now I know what I didn't know, that if a client comes in, I will provide that advisal. Now, I just need you to know, and maybe I've said this, that Ohio is one of 2 states that does not have a strangulation statute. We have a bill that passed the House, and as part of the bill, that advisal would be written into our statute. Additionally, when we ask police to do those lethality assessments for high risk, what is put in our statute is strangulation is automatically high risk. Hopefully, we will have a bill that passes because it will make it easier to educate our community. Additionally, strangulation, as all of you or most of you have said, is a risk for suicide. The studies have shown that the risk factors for suicide are gender, female, low socioeconomic status, many legal aid lawyers know this, lack of education, employment, increasing age, not married, not having a job, not working out of the home, and domestic violence. And many of those clients, especially those that have been strangled, attempted or contemplated suicide. That is something to watch. When I tell you to look at your client's behaviors, your client may not feel this on day one, but maybe 5 days later, 2 weeks later, that client is despondent. That client talks about killing themselves. That is something that you need to look at. And you need to know who to refer that client to. Next slide. Oh, you have it. A client is 12 times more likely to commit suicide if they have experienced intimate partner violence. They are more victims of domestic violence, die at their own hand than that of their abuser. And it's not just the victim adult. It is that non-offending child as well. A child has a 2 to 5-fold increase in suicidal behavior for children who are exposed to domestic violence. And these are what the studies show. Additionally, there have not been as many studies on those that have actually completed suicide, but this is an area ripe for attention. Additionally, next slide. The survey results for women who have been strangled, if you notice, suicidal ideation is 31%, up with memory deficit. That is significant. And it is up to us to talk to our clients because we, civil lawyers, are also and can be the gatekeepers and those first responders because many people, like we've talked about, don't go to the police or do not go to the prosecutor. And what is very important to know is that our clients will not associate the symptoms of depression and despondency with the idea of strangulation. They normalize those behaviors. Margaret?
Maybe. One of the most devastating consequences of strangulation is a traumatic brain injury. And in the fall of 2019, the Journal of Women's Health published an article regarding a pilot study that was done in Toronto to try to look at the relationship between traumatic brain injury and intimate partner violence because it is a significant health concern. And they surveyed service providers in their community, 68 agencies, in 2 ways. The one was an anonymous online survey, and the other one was a workshop. And the purpose was to disseminate existing knowledge and to develop a knowledge to practice network about the relationship between TBIs and intimate partner violence. The results showed a general lack of traumatic brain injury awareness and understanding among intimate partner violence service providers, and that frontline workers and sometimes the survivors themselves did not recognize the signs and symptoms of traumatic brain injury, and therefore recommendations were made to address this lack of knowledge and these gaps in both the professional area and as relates to the victim. So therefore, there are some helps that we offer to you in dealing with victims of traumatic brain injury as a result of strangulation. Next slide, please. Right. So ask your client, have you ever been hit in your head or hit on the head? Were you ever seen in the emergency room, hospital, or received any medical treatment because of an injury to your head? Did you ever lose consciousness or experience a period of being dazed or confused? And do you experience any of these problems in your daily life? Visual problems, auditory problems, sensory impairments, paralysis, weakness of any extremity, balance problems, fatigue, apathy, silliness, impulsivity, mood swings, irritability, decreased self-awareness, decreased ability to learn new information or retrieve old information, shifting from one topic to another, difficulty in setting and executing goals and tasks, and problems with monitoring and abstract thinking. A traumatic brain injury is a paradigm shift in a person's life and that of their loved one. Also, there are sicknesses that can follow, or the exacerbation of existing sicknesses. So ask your clients about this because it changes their ability to conduct day-to-day activities. But not just for them. If it is a severe traumatic brain injury, it is a consequence that has to be addressed by the family or their caretakers or their loved ones, because people are not able to do simple things that they used to do. And they require patience and any kind of counseling or other support services that are available in the community. The first thing is a very, very difficult time in facing and adjusting to the change in their lifestyle, what they're not able to do anymore. Sometimes traumatic brain injury patients have to learn to walk again. They have to learn to eat again. They have to learn to take care of their personal habits, and they may not be able to do that, or their personal hygiene as easily as they were before. But most especially is the recognition that there is something so different about the way I have to live my life now. So therefore, we encourage you to explore what's in your community about strategies that can be put into place to help victims of traumatic brain injury adapt. I would strongly encourage that you exercise profound patience with them. Listen to them about what they're experiencing, because they know something is different. Listen to them, listen to their fears, listen to their insecurities. Listen to them when they may tell you that they don't want to live anymore. Realize that their whole life has undergone a profound change, and help them learn what they can do to maximize what it is that they can do. For instance, you may have to write things down for them. You may have to develop various tactics for helping them with their memory. You may have to break tasks into very, very small, tangible steps, and you may have to repeat the small, tangible steps. You have to give extra time for them to do things. You need to be respectful and positive with them as you help them adjust and adapt. And realize that you can't say, do this and then this and then this and then this, because they're not going to remember. They may not remember the first thing you tell them, let alone a sequence of events. Speak slowly, but don't talk down to them as if though they, or just don't understand at all. Just try to find what they do understand and where you have to help them. You may have to repeat a lot of things, and you may need to seek immediate medical attention. You also need to be mindful that very often traumatic brain injured victims need long-term counseling, as do their family members, because their lives have not only permanently changed, so have the lives of their loved ones and the people who have to help them. So very often counseling can help as they adjust to these changes as a result of what has happened to them. Remember, their brain has been damaged. And we've talked about the medical change in a person's brain as a result of strangulation. A person's brain has been damaged traumatically, so therefore all the brain functions that flow are going to be affected by that. Educate yourself and be patient with them. There are other resources available to you from the Ohio Domestic Violence Network about how to work with traumatic brain injuries. Look for the traumatic brain injured organizations in your community or your state. They can be immense resources in helping you help your clients who have suffered from this awful consequence as a result of domestic violence. So educate yourself about what to do, and be patient even with yourself as you help your clients, because they are going to be different in how they communicate, how they respond, how they react, and realize that even though there's a they have suffered traumatic brain injury, look for the things that they can do. Very often, there are artists or there are musicians or there are other ways that they can contribute, and encourage them as they do that, because they need that help in feeling that they are positive participants in society. Gail? Gail?
Sorry, I muted myself. See, I followed the instructions, but then you got to follow the second set of instructions to unmute yourself. Okay, so what we're doing now is we wanted to go into safety planning, and before I go into that as to this new tool, I just want to make a couple of comments. One, I think all of us have, wait a minute, I think we have a poll. I think we did the poll with safety planning, or we're just going to do it again. Let's go ahead and do the poll. 100% said yes. Well, there you go. Oh, we didn't finish the poll. Okay, so from what I'm seeing is that most of you are doing things right, which is awesome. And some of you, these things may not apply because of where you're working. But I think making sure that this is happening by someone, somewhere. And if you're the attorney, then making sure all these things happen before your client walks out the door is critical. So we're going to go ahead and close that poll. I feel healed, which is great. So when it comes to safety planning, a couple of things I learned working at the Family Justice Center and running our restraining order clinic, that just like Margaret said, and also what Alexandra said, our clients are coming into us and they are traumatized. So a couple of things that we did as we were asking survivors in our focus groups, what can we do to make this system better? One thing we incorporated was the power and control wheel. So while they were waiting to talk to an attorney, we just had them read through the power and control wheel, and that helped them remember a number of things that happened to them. The other thing that we realized is that when we're going through the process, while we were doing safety planning, it wasn't really quite meaningful at that time. And in our study, we also found out that there was a lot of stalking behavior after the client got the restraining order. So we actually asked them to come back just for us to talk about safety planning and how to document stalking incidents. But also something happened in San Diego that will stick with me forever. It was a case where a civil attorney was working with a victim who was at high risk. He asked us one question, we found out afterwards, what do you think he's going to do when he gets served with the restraining order? She said he's going to freak out, he's going to come after me, and then the attorney also became concerned for her safety. So what ended up happening is that he ended up going to her house to try to comfort her and kind of be there in case anything happened. Well, he did get served, her abuser, and he came to the house with a gun. He shot the civil attorney, shot the mother who was there, tried to shoot the son, but he got on the roof and kind of like ran, shot his wife, and she survived. And that story never, ever left me, because I think when we are doing safety planning, we are just thinking about our clients. So I would suggest that we all need to be thinking about safety planning for yourselves as well. And when it came to safety planning, we also asked survivors what they needed for us, and we incorporated a new safety technique about, okay, we're going to meet you at court. I want you to park at different places. I want you to walk to the courtroom in different ways. If you feel concerned, we will have court support with you, and we will escort you out, or we will notify the bailiff in advance that you could be at risk. I'm just stunned at how many times I have seen live and in person the witness intimidation that occurs. And I've seen it more than once because when we work with the Family Justice Center community, we always go to court and observe, and I see it outside the courtroom and even inside the courtroom. So safety planning has always been on my mind, and when it comes to strangled victims, learning about them being robbed of hope has stuck in my mind. And the reason why suicide has also been part of, like, what is the answer to that? In our original study of 300 cases, we had one client who actually died by suicide and two who tried to commit suicide. So it was heartbreaking for me because I go, oh my gosh, we've gone through all this. You've gotten restraining orders. You called the police. We got them convicted, and something is still happening, and that is being robbed of hope. So our organization has been really interested in the science of hope, so much so we changed our name from the National Family Justice Center Alliance to Alliance for Hope International. And everything we're doing now is integrating the science of hope, because I didn't realize this until like about 7 years ago, that there is a science to hope and how science can heal and help people move forward who are going through traumatic things. So this safety plan, which one of my law students found, because as I said before, I have them find things on their own. I have each one of them find me a safety plan, and one gave me this one. I never seen that before. I had seen all the typical ones you normally see, and probably the brochures you have in your office, because so many of you responded, you do safety planning, but I never saw one that related to goals, options, and risks. So I just wanted to give you a heads up. It's out there, and we are now adapting it to integrate more of the science of hope with risk assessment, goal setting, and safety planning. I know that right now we're at 12:34, so I can't give you like 1 hour's worth of what is the science of hope, but I can give you a couple of things to go to. Most recently, Casey and I wrote this article for the Domestic Violence Report. As I mentioned, it's haunted me about suicide ideation, and it's called Being Robbed of Hope. And over the years of being a prosecutor, there had been a number of cases where victims had committed or died of suicide. This is outside of our strangulation study. And we always felt like justice was never served, and obviously there's a reason why victims do that. But because we were already doing evidence-based prosecution, we decided to keep pursuing those cases no matter what, and we took a lot of heat for it because the defense bar and the court said, why are you pursuing this case? She's dead. And I go, she may be dead, but justice has not been served, and we all know that there's going to be another victim. So we went forward on evidence-based prosecution, got our convictions, but it didn't solve the problem. And so a couple of years ago, I saw an article in People magazine where this DA from Minnesota actually prosecuted a batterer for the victim who died by suicide. It was well documented. There was a long history of abuse. It was well documented. He was torturing her, history of concussion, strangulation, stalking behavior. This is all after she left. She was in counseling. Somehow he was managing to get text messages to her. She eventually said, I'm out. I don't want any more counseling. I'm just going back. And it was reported in the People magazine that she said, I'm already dead, so what's the point? And in a matter of days, she died by suicide. And that DA went forward on that case. He charged him with murder by depraved heart for all the things that he did. He was not successful with that charge. He was successful in proving like 2,000 violations of the restraining order and stalking, and he got convicted and did serve a significant period of time. But still, it wasn't like the answer. And so I just wanted to share with you that in other countries, they are actually passing coercive control laws, and prosecutors in other countries are successfully prosecuting offenders who cause so much pain, so much suffering, and charging them under coercive control when the victims do die by suicide. And I don't know, for whatever reason, it kind of gives me hope. But about the science of hope and what we're doing is I wanted to share that Casey Gwynn, who's our president, and Dr. Chan Hellman, who's actually taken a sabbatical from his university as a professor, he is now with us for 1 year. And what we're trying to really figure out is not only how do we take that bigger safety plan and integrate science, but the science of hope into that safety plan, but how do you integrate the science of hope into everything that we do, and how we work with clients, how we create a hope-centered organization. Because what I've learned about the science of hope is that you can increase your own hope scores. And we too, just like you have to do safety planning for ourselves, we too can be robbed of hope by all the things that can happen. And right now I'm being robbed of hope by just seeing everything that's happening in this world. And you have to really kind of take care of yourself in this effort. So I don't have the time that I would love to share what I've learned about it because I feel like I'm a student, but I wanted to give you some resources that it is worth considering and integrating into your work. We actually took the Hope Scale, had a number of family justice centers implement this into their family justice center, because we said if we're going to provide services at a family justice center, hopefully we're increasing hope and not robbing clients of hope. And we have found that family justice centers do provide increased hope by how we treat people, the information that we share. It all kind of makes sense. But if you have a higher hope score, you do much better in life. And if you have a lower hope score, you don't do as well. So it impacts your life, it impacts your work, it impacts your outlook. But definitely wanted to share that with you. There's also a YouTube, Science of Hope. This is a short version that you can take a look at, and or you can buy the book itself. We are now integrating it, as I said, not only in our work, but also in family justice centers. And as we kind of wrap up here, as we get to the next slide, we did want to open it up to Leadership Matters. But as I wrap up, I would say when it comes to strangled victims who we have already proven are robbed of hope, we did a poly-victimization study with family justice centers, and strangulation was like the top 10 thing. And Dr. Chan Hellman just showed me the results of that, and he said, Gail, I know you think victims have been robbed of hope, but I can prove to you that they have been robbed of hope. And that gave me another a little kick, like, okay, we really need to figure out this bigger. And we just had our master's course, and this will be on our top 10 things that we will be doing with Dr. Chan Hellman and our Voices groups, because we work with a number of survivors who serve as our ongoing focus group. As we create new things, they give us feedback, and they tell us how to improve things, or sometimes they tell us we should delete things, and we listen to that. So now that we are at this point, I want to bring it back to our two champions in the civil side of the world. What can civil attorneys do? So Margaret and Alexandria.
Okay. To me, what they can do is what I just started to do. You need to invite somebody from your court, preferably a judge, to become one of your champions. They need to know what you are learning. They need to believe it and feel it like you do. We have done a series of high-risk lethality factor trainings with our Bar Association. And now we're taking the people who went and wondering if we can create a cadre of experts from these people, or at least people who want to know more. The person who did our training on strangulation, we had Gail and Casey come to Columbus. We had statewide training through the Supreme Court. We had Ruth Downing train our Bar Association, family law section, and high-risk court section on strangulation. I cannot tell you how many of the people we trained want more. How many of these people needed to know more? We need to see about laws and passing laws. Like I said, we're in the process of doing that. We have now, through our coordinating council, I contacted the chair and said, we're going to have to start a strangulation committee so we can bring in law enforcement, EMS, prosecutors, civil lawyers, judges, forensic nurses, bring in everybody so we can think about how to do training, whether it be multidisciplinary or whether it be specialized. And if we're not creating experts, we're at least going to create specialists. And then lastly, I think it's very important to look for new theories. What I didn't say when I talked about strangulation is the idea that, when I talked about recantation, is the idea that if you have a client who's not available because of that jailhouse call or because of what the abuser has done, through his wrongdoing, in the criminal context, there is a hearsay exception, forfeiture by wrongdoing. Since we have suggested that you apply some of what you've learned from the criminal cases, it's very possible. I'm trying to think how we create a theory of civil forfeiture by wrongdoing and try to use that in some of our cases in the civil context. Thanks. Margaret? Margaret?
Probably is muted as well.
Yes, I was. Excuse me. As Gail said, when you know better, you can do better. And in that, the decision makers very often are the judges. It is my goal to try to see if I can advocate for training here in our community of our judges, but also across our state by appealing to and talking with our chief, the Chief Justice of our North Carolina Supreme Court. Because I think a lot of people do domestic law and do domestic violence cases, but do not know of the intricacies and the danger and the lethality of strangulation. And to start locally, in that we can start with our local family law bar. We are fortunate in Guilford County and in Alamance County of having in place family justice centers. So we do have the collaborative approach in the delivery of services to the victims. But I think we can expand this knowledge to hopefully give more information to the bar and to the bench so that we can ensure safety for people and more offender accountability. Gail?
Oh, there you go, that muting again. Okay, so here we're going to go. It's 12:44. I'm going to wrap up this next piece so we can open it up for questions. Number one, I wanted to share this new article that came out about multidisciplinary teams. We've been talking about working together. As we all know, it has proven to work. So if you don't have a team already in place, dream big, start small. You can have a coordinated community response. You can have a subcommittee in your DV council. You can create a meet and greet, whatever you want to call it, but calling a meeting is what's key in sharing this information. Two, I had to share this Diaz case because Diaz is a case that just made me go, holy cow, in a good way, like holy cow, because it's yet another way. If everybody is trained, what can happen? So here's the holy cow case, and I'll do it very quickly. We're getting ready to do some training in Louisiana, and as I always do, I try to read what is the current case law, what's happening in that particular state or jurisdiction. I find out about the State versus Diaz, which is an unpublished case, and as I'm reading this unpublished case that was where strangulation was charged as attempted manslaughter, just that made me go, holy cow, because when we started to do this work, strangulation was barely being prosecuted, and if it was a misdemeanor. And holy moly, how did we get to attempted manslaughter? Because they were trained. So here's what happened. The victim is strangled to the point where she loses consciousness. She goes into that, oh my gosh, she's going to kill me. She is fighting to break free. She does. And she tries to run out of the house. But he grabs her by the hair, pulls her back down, sits on top of her, strangles her again, and now she's screaming because she says, I don't get out of here, I'm going to die. He then stuffs a plastic bag down her throat, fights even harder. By a miracle, she breaks free, runs out of the house with her phone. It's like a scene in the movie because she's like running out of the house, sees a bus, jumps into the bus, and on the bus, she's calling 911. On the bus, the 911 dispatcher clearly has been trained because she says, I have called the paramedics. What you've just suffered is serious. They're going to be at the next stop. I see that the next stop is at the corner of X and X, at the corner of Hope Street and Hope even more, and you've got to stop. So when the bus stops, the paramedics are already there. They're trying to find her. They tell her, you got to go with us. We're transporting you to the hospital. The police officers are there as well. They take her statement and ask her on body cam, and the body cam was on. They find out he tried to kill her because she also reported, he said he was going to kill me. He did it repeatedly. What did you think he was going to do? I thought he was going to kill me, and I thought I was going to die. The police, which I never heard of, calls back to dispatcher and says, you need to change the code. This is not an assault. This is an attempted manslaughter. And I'm going like, holy cow. And not only did they do that, they sent the crime scene investigators to the scene to document the residence after they documented the photos of the victim. And they also tracked him down, found him, and arrested him. Then, but wait, it was like more, like an AT&T commercial. They transport her to the hospital, and she's going like, you know, I'm fine. I've got no visible injuries, no symptoms. But the doctor, who's also been trained, orders a CAT scan and says, I need to get a CAT scan. I can't, like, see through your body. There's only one way I'm going to be able to rule out any internal injury, and that is if I get a CTA. So as you can imagine, between now and the day of trial, he starts calling her from jail. He starts getting her to try to minimize everything. She ultimately does testify. She does minimize, but she does not completely recant. The prosecutor doesn't drop the charges, goes forward with all this amazing evidence, gets the doctor who ends up testifying for the first time, not only as a precipient witness, but as an expert witness, to talk about how serious and dangerous strangulation cases can be. And even though that the CTA came back negative, they really saw that as a positive in the sense that why would a doctor order that unless this really was serious? So I'm thinking, oh my gosh, you don't need to worry about a recanting victim if everyone in the system gets trained. So to me, the Diaz case is a case of total inspiration, and it inspired me, and I hope it inspires you that we can turn things around, because New Orleans was a community that had corruption. They had the Department of Justice come in. They had all kinds of challenges, especially right after Hurricane, and they went from everything being wiped out to resurrecting themselves and changing the way strangulation, domestic violence, sexual assault cases were handled, thanks to the leadership of Mary Claire Landry and all of her colleagues. It's just an inspirational story. So we've got a lot of resources. You got it in your Dropbox and at the end of this. So let's go ahead, Anya, and open it up while we have maybe like 10 minutes left for questions.
Sure, thank you. And first, thank you, Gail and Margaret and Alexandria, for all of the information and content that you shared. There were a number of questions that came up, and so I'll just go through those for you now. The first was, I think, a specific one that may warrant some post-webinar technical assistance consultation, but I'll still read it to you for any general thoughts that could be shared. And I will note that some of what you covered addresses this, but perhaps we can give a more tailored response to the question. This one comes from Christelle, who has a client who at the time of the strangulation was advised to go to the emergency room, and this was a year or so ago. And the hospital did not conduct any imaging, but did comment that the client had sustained neck injury and that there were no visible injuries pursuant to the police. And so now Christelle is engaging in a domestic violence protection order or restraining order case, and is wondering how to sort of bolster the claim that this client had sustained injuries aside from the fact that the client did choose to go to the hospital, and what the client can testify to as what she or he felt at the time.
Okay. Well, I will take that first and then ask my amazing panelists to share more. But I would say with, thank you, I think it was Crystal for asking that question. I'm not surprised that the ER did not order a CTA. Their general bias is no visible injury means no internal injury, so they're not inclined to do it because there is no protocol. So what I would do is in your pleadings for the restraining order, I would probably get an affidavit depending on where you are. I can certainly connect you to a local expert that can say, if called to testify, I will testify to the following about A, B, and C. I take a look at our trial brief that we included as an example. I would also ask the court to take judicial notice of a couple of things. One, there is that article from Kentucky that just came out in 2019 that basically says that if you are strangled, you have essentially 1 out of 47 chance of having a carotid dissection. There's also a lot of articles that say when it comes to domestic violence in general, the medical community has let victims down because of a lack of training and have a tendency to minimize it. And as Alexandria already said, just because it wasn't handled appropriately doesn't mean you can't do it now. In other words, I would ask all of, like, what are you experiencing now? Because she probably has PTSD, she probably has a traumatic brain injury, she probably has symptoms that you can document. And under the category of using an expert, you can have your client seek medical attention with somebody that has been trained in strangulation to get an adequate diagnosis. So there is a lot you can still do even though it wasn't done right the first time. I'll open it up to either Alexandria or Margaret for their suggestions.
I would also look at the danger assessment information that we have shared with you today to question the client about whether or not she experienced any of those things, and pay careful attention to what she says about what she experienced. She can describe what happened to her and describe it with specificity and in detail to paint a picture to the court about what she actually experienced. That also try to determine if there were any eyewitnesses to the strangulation and interview those witnesses very carefully. But I agree with Gail, there are resources that are available to you to try to paint a clear picture to the court of what the client has experienced.
And if I may add, everybody said just what I would have said. The only thing that I would do as well is if I have my client on the stand, I would ask her every question that is in the toolbox. And I know that, Gail, you have created questions for police, for prosecutors, questions for anybody to ask a client. And as Margaret said, you ask all of those questions so the court can do nothing less than issue that protection order. And as I know it's been said, if you have to go to trial, have a written closing argument, because if you can't get the court to take judicial notice of any of the pleadings, you can either put them in your petition if you haven't filed yet, or you can put them in a written closing. And I think if you haven't done that, that's the way I would go.
I just thought of something else.
Me too. In addition, in addition, this webinar is for civil attorneys. So in addition to the restraining order, get that client to a civil attorney to see if she has any other causes of action that may be applicable, and file a lawsuit against that person. Did she lose any wages? Did she lose time from her work? Did she have to incur any counseling expenses? Did she have to relocate? Any other available cause of action in the civil context that is available to her. Get her to a civil attorney and have that person sue on her behalf. Don't just stop at trying to get a restraining order. Gail?
Okay, so what I thought about is lately I've been filing a lot of public records requests, and they're not easy to do, but we're getting better at it. And what I would probably do is go first to their website to see what they have about domestic violence, a hospital that denied your client or your victim the CTA. And then I'd also, if I couldn't find anything on their website, I would probably do a public records request to see what they do to screen victims for domestic violence and if they have a policy related to strangulation. You're probably going to find the answers no and no, which then will give you a statement to the judge why this didn't happen. Just because it doesn't have visible injuries doesn't mean it didn't happen, and you have a hospital that doesn't get it, so it makes sense that she didn't get the CTA. And the other thing is that when you mentioned that the police officer said there was no visible injury, we are now training police officers to say no visible injuries at this time. So the other thing is, did she have any bruises after the fact, and who saw those bruises? It could be a friend, it could be somebody she lives with, or it could be somebody at work. But I would say let's find out what happened afterwards, all the signs and possible symptoms. Okay, Anya, I think we're done on that one. If there's one more, we could
thank
probably
you.
sneak
And
it in.
I think we're not going to be able to answer any more questions now, just to be fair to participants and to everyone to end on time. But I will note that our Joelle, Allison Carter, Kathleen Allen had questions that we will respond to when the webinar ends, and we'll reach out to you directly. I've also pasted in the chat box the technical assistance link for the ABA, as well as the email for Alliance for Hope. And Carly, feel free to add in any other links that are more successful. I think there's a few things that we can keep talking about now, Gail, about what you and your team can do after the fact, as well as the ABA. But I will take one privilege of being the moderator back here to just note that a number of times there's reference made to how challenging these cases can be for lawyers and other system actors who are working with survivors of strangulation. And I think that there is immense pressure, especially for those of us who've been enjoying this work due to our own experiences as survivors, to take these cases on as if they are our own life or our own sort of experiences. But what we know is that that can only really lead to oftentimes quite significant secondary trauma or vicarious trauma. And we're all doing this work in the context of a pandemic, which is in its own right a source of trauma for all of us trying to live our normal lives as well as our professional lives. So I just wanted to note that at the Commission, we spend a lot of time working on individual and organizational responses to trauma. I'm sure that the Strangulation Institute, Alliance for Hope International also must, given just the severity of strangulation, but I wanted to offer that you can reach out to us at the ABA if this is something that you individually as a lawyer or your organization are struggling to address. And I'll let you, Gail, sort of close this up, and then I'll speak about the ABA's Technical Assistance Project. Thank you.
Got it. So this is how you can join our mailing list. It's been up for a little while, so I'm assuming you wrote it down. This way you can be advised of upcoming free trainings. This is how you can reach me with any of the questions that have not been answered. You also have my cell phone number, and you have our website. Margaret?
Yes, and you can reach me at Elon School of Law in Greensboro, North Carolina, and at margaretdudley43@gmail.com. And I will help you in whatever way that I can.
Alexandria?
And you can reach me at the Legal Aid Society of Cleveland, and my email is up there, and you can also call me at 216-861-5713, and I'll be glad to help. And again, thank you very much for hearing us today.
And thanking to OVW for letting us do this. It's been fun working with the ABA. It's been absolutely a privilege working with Alexandria and Margaret. I want to thank both Anya and Carly for managing the freeway and the chat feature, which was just amazing to watch. And thank you all for really giving us this opportunity to share what we've learned, sharing our passion, and hopefully together we can change the outcome for survivors. Back to you, Anya.
Thank you. So thank you again. I've said this a number of times, but truly to Gail and Margaret and Alexandria and Carly from the Alliance for Hope. I'd also like to thank Jane and Sylvie at the ABA, and also Stephanie at NCJ, FCJ, and Daniel, who really helped around the technology, as well as to our invisible but ever-present captioner. So thank you for that. For those of you who are attorneys and civil legal attorneys, we're one of your OVW LAV grantee technical assistance providers. Anything from small questions to larger, broader umbrella questions, we're here to answer them for you. We have a TA link that's in the chat box. We have office hours where we can Zoom with you and really talk about a range of issues you have. We have a number of additional webinars, Zoom sessions, and written materials that are coming out soon. But again, thank you all for joining us. It's really important for us to talk about strangulation, something that has not had as much training attention in the civil legal arena. So we're really grateful again to Gail and her team for bringing this to all of us. So thank you again, and everyone stay safe and be well.
Thank you.
Thank you. Bye.
Thank you.
Bye.